Hi, everyone. Welcome to Crime in Court. This is the 1996 Menendez brothers trial, California versus Erik and Lyle Menendez. This is their second trial of the homicides of their parents, Kitty and Jose. First trial ended in a mistrial. We are comparing and contrasting the two trials. We only have, unfortunately, the transcript in this case, so we don't have video, but we're getting through it the best we can. We're almost through the state's case, and we've got about 1 to 2 witnesses left where we left off last time. So on Friday, we left off with so Dr. Roger McCarthy is still on the stand. He is the mechanical engineer, not a biomechanical engineer, which there's a big difference. So the mechanical engineer that the state brought for their expert witness couldn't be there on Monday. He had some prior speaking engagement or something. So they booked some other people to testify. We heard from uh, Detective Zoller, the lead detective, Detective Les Zoller, and very briefly. And we also heard from a Kurt Kuhn for the defense. He was with the Beverly Hills Crime Lab, and she questioned him very briefly. Now they're done with that. The jury is going to go home for the day, but there's going to be legal argument. They're going to have to use up some of the time that is because really they only they only had testimony for about an hour, and then they're going home for this particular day. This is Monday, November 13th, 1995. So we're going to continue on right where we left off, which was the jury was going home for the day, and Kurt Kuhn was done with his testimony, and now the following proceedings are held outside the presence of the jury. Ms. Abramson says, "That's it. Sorry." The court says, once the jury is gone, there could be use of the time to either go through exhibits or identify things that can be litigated further that have to be litigated that can be done today. Anybody give any thought to that? Ms. Abramson says, "What I would vote for is those I leave behind, go through exhibits, and I leave and go do the work I have to do to prepare further for all the physical evidence witnesses who are all mine. So I would vote that everybody else go through exhibits." The court says, "Well, it's not a question of who does it, it's whether it can be done. Have you talked at all about this going through exhibits so far and seeing if there are any disputes or some exhibits that can be received so the clerk can get a head start?" Mr. Khan says, "No, we haven't done that yet. I think we should do that this morning." Ms. Towery says, "It might be better use of our time if we look through them the rest of this morning and talk this afternoon about it. I haven't looked at the list at all." Court says, "Also, there's still a dispute about a transcript of the Oziel tape recording. Have you tried to isolate or limit the dispute?" Ms. Towery says, "I am comparing these two. I'm in the process of doing that." Ms. Abramson says, "That's the other thing I have to call Zoller about, getting the rest of the September 17th part, what the people were objecting to. We would try to deal with that. I think they lost on that, or I think I won on that." The court says, "Is there anything that can be done today?" Ms. Towery says, "I don't think I can do it today. I'll try. If we're going to talk about exhibits, I can't finish that." The court says, "At the very least, maybe you and the DA can confer." Ms. Towery says, "What I plan on doing is comparing the two to each other and see if there's any discrepancy, then listen to the tapes. I've been carrying them around with me." Court says, "I'd like the lawyers to do it. There might be very few disputes. I don't know. I'm going to let the jury go." Ms. Abramson says, "Can I be excused?" The court says, "As long as everyone else can deal with it without you." So the following proceedings are held. The jury is gone. I believe so. Ms. Abramson is leaving. So the court says that's all they have today as far as testimony of witnesses, and we'll resume with the jury tomorrow at 8:30 when Dr. McCarthy returns, and he'll be on the stand tomorrow and probably for a couple of days more this week before his testimony is completed. And the lawyers will stay behind this morning and into the afternoon to assist the court in going through the exhibits. We have 277 exhibits marked so far. There are a lot more that will be marked. It will be of assistance to the court to review the exhibits to see if there are any disputes about which exhibits can be received in evidence and given to the jury without deliberations. He doesn't need to explain all this to the jury. And this has to be done at some point during the trial. So we'll get a head start on that, and the lawyers will do that and help the court in dealing with physical exhibits that will ultimately be given to the jury during deliberations. That obviously doesn't require the jury to be here. Therefore, I'll excuse you and ask that you return tomorrow at 8:30, at which time we should have a full day of testimony, and for the balance of the week, see you back here tomorrow at 8:30. The jury exited the courtroom and the following proceedings are now held. So that was his announcement to the jury. I don't know why he got into all the details of what the lawyers are going to do while they're out. He could have just simply said the lawyers are going to be working on some things to make use of their time while you guys are go and enjoy the rest of your afternoon. Like that's all that needed to be said, but he got detailed about it. I don't know why. All right, so the court says, and now this is without the jury. As we discussed then, counsel will review the exhibits this morning, and then in the afternoon, if there are disputes, we can discuss them this afternoon. And if some counsel feel that they can defer to others to deal with these matters, then those who want to leave can do so, and those that remain behind will be left with the responsibility of resolving any of the disputes. We'll be in recess until 1:30. Mr. Levin says, Your Honor, may we just have a moment? The court says yes. The attorneys confer. Mr. Levin says, Your Honor, the defendants wish to waive their appearance and get back to the jail so that we'll save some time when I go see my client. The court says, Okay, we will be discussing disputes if there are disputes about exhibits which will go to the jury. These disputes, when resolved, might be resolved over the objection of the defendant's objections. Defendants might have objections to the receipt of exhibits or how they appear or things of that nature. Each of the defendants have a right to be present for the discussions and to hear what the objections are, to hear any issues that your lawyers want to bring up as to what the exhibits will be and how they'll look, whether they go to the jury. It's up to you if you want to be there. You can give up that right if you want to, and have your lawyers represent your interests without being present. It's up to you. What do you want to do? Mr. Levin says they're going to stay, Your Honor. So the court says, we'll be in recess until 1:30. Ms. Abramson says, thank you, Your Honor. They're probably just bored because they're probably just sitting in like a holding cell, which has nothing for them to do. So getting back to their prison, they have, books and things that they can do and write and draw and whatever they do to occupy their time. They don't have that in the holding cell, so they're probably bored as heck. Anyways, all right, so the court says, in the trial, the defendants are here, counsel are present, the jury is not. Counsel have been conferring about exhibits. Why don't you fill me in on what's occurred? Ms. Nahara says, well, Your Honor, what we've done in this case is that the defense has submitted to us and we submitted to them what it was that either side would be offering, and then both sides went over each list rather carefully and then basically presented each side with our set of objections for each other's offered exhibits. So right now we're at a point where everybody knows what the other is objecting to in terms of exhibits. It's how the court wants to proceed with which group you want to deal with first, or both of them, and we can give you the objections. The court says, how many are there? Ms. Nahara says, as to the people will be objecting to 18. People will be objecting to 18 defense exhibits, and the defense is objecting at this time to 27 of the people's exhibits, and also they informed us that they are not prepared to make any kind of determination regarding exhibits 167 to 278. Mr. Gessler says, those exhibits are still ongoing, Your Honor, as Dr. McCarthy is testifying, and I feel that we should reserve objections. Many of them certainly are unobjectionable, but reserve objections on those until we get to the conclusion of that testimony. The court says, okay. Mr. Gessler says, but we are ready, I think, to proceed on the majority of the exhibits that have been done before we got to the medical and reconstruction aspects. Court says, okay, let's do this then. Since the people are about to rest, let's start with the exhibits that they're offering and deal with the defense objections to them, and then we will, when we get time, if we still have time today, deal with the reverse of that. Okay, so why don't you just tell me which exhibits you want to talk about here? I guess since the defense is objecting, why don't you tell me which ones you want to talk about first? Mr. Gessler says, well, again, Your Honor, part of it is the people are not offering all exhibits that have been marked. The court says, okay. Mr. Gessler says, and so the fact that I am not objecting doesn't mean that it's only going to the ones that we have been given notice that we are going to seek admission to. Court says, right, okay, I understand. I would, Mr. Gessler says, for example, the people are not offering Exhibit 29, to which we had previously objected. So, the court says, let's not then deal with those that they're not offering at this point or even dealing with. The court says, and this is a photo, so something happened, there's redactions again, it seems. I don't know why, but there may be some redactions in these transcripts. The court says, and this is a photograph of item number 13, and my notes indicate that it was nowhere identified during testimony. Mr. Gessler says, I believe that's correct. It was not used in testimony. It is a hand, I believe, of Jose Menendez with a gloved hand at the scene, obviously exploring part of an injury. It seems to contain a lot of blood and particularly no evidentiary value, and we are objecting on 352 grounds for that particular picture. Court says, well, regardless of 352, I don't think it was ever identified in the testimony unless it came out during some later testimony after it was initially marked on October 12th. Mr. Gessler says that's true. Ms. Nahara says, Your Honor, it came out, I believe, with the chart that's out there, which is 24. Was it was sorry, but all these little words and like they're getting jumbled in my head. What it was is it showed where evidence number item number 13, which is on chart 24, was found, and Detective Zoller testified that there was wadding. That the court says, let me say that there was an objection at that point. Ms. Nahara says correct. Court says, I believe I would give sort of an educated guess under 352 at that point, and it was held off as far as whether it was going to be referred to by Detective Zoller, and I don't think you ever picked up on it later on. That's my notes. So at this point, it has never been identified. Ms. Nahara says, Your Honor, that's something Mr. Khan believes that he did, Detective Zoller, that he, in fact, was asked about this, but it wasn't shown to the jury. So perhaps we should hold off on this and look it up in the transcript. The court says, hold off and see if it was ever identified. Ms. Towery says, is the court saying it was never identified at all or used subsequently? The court says it was marked as an exhibit but never shown to Detective Zoller and never identified. That's my recollection and notation. I have the same notation as to Exhibit 29, actually. Now, whether later on it was identified, I didn't change my notes. I can't tell you. But first things first, it's never been identified and it can't be received. Ms. Nahara says, that's fine, Your Honor. The court says, what's the next exhibit? Mr. Gessler says, the next would be the series 50, 51, 52, and 53. This is the series, tapes of the September 17th statements of both the tapes and transcripts of them with Erik Menendez and Lyle Menendez. The objections are those that we have previously stated on Aranda grounds 352, that limiting instructions are insufficient. The objections previously stated in a 402 motion before the court. The court says, okay, those objections are overruled and they will be received 50 through 53. Mr. Gessler says, the next objections, Your Honor, are, well, first, it's 59, which is the December 11th tape. The objection there is on all grounds previously stated in 402 motions and other motions before the court, writing and orally. Court says, okay, it will be received over the objections and rulings previously made by the court stand. Okay. I just love it when judges just don't give a crap when you're arguing for your client. Mr. Gessler says, as to Exhibit 60, we would ask the court to defer ruling. There is still negotiations going on as to which transcript or amalgamation of the transcripts should be used. Court says, okay. Ms. Towery says, and just so the court is aware, Ms. Nahara gave me a copy of the People's Transcript that they intend to offer this afternoon, which she indicates to me is basically the same as prior Exhibit 322. But I do need to go through that and check it and did have an objection to it. 322 is Exhibit 60 in this trial. The court says, okay, we will hold off on that. Ms. Nahara says, okay. Mr. Gessler says next objection would be to Exhibit 89. This is a tape recorded statement of Perry Berman. I believe it was used to refresh his recollection for one portion of that tape only, and I think it's improper for the people to offer it. It was their witness. I think that a tape for refresh recollection or past recollection recorded can only be offered by the opposing side as to the part that is relevant. The court says my notes indicated it was offered to impeach the witness. Ms. Towery says, Your Honor, I looked that up. This is Exhibit 89. Court says yes. Mr. Gessler says this is Exhibit 89. Ms. Towery says, my review of the transcript indicates it was used to refresh his recollection regarding what he said to Sergeant Edmonds when he was interviewed. Only a portion of the tape was played. That's at volume 224, pages 37,000 through 37002, and that was over defense objection on improper impeachment and relevancy grounds. And then I believe that Ms. Nahara her first question after playing it was, does that refresh your recollection? And he said, yes, I guess so, or something along those lines. The court says, again, what were the pages? 37 what? 37,000 through 37,002. 37,002 was the testimony about refreshing the recollection, and that's volume 224. Court says, okay. Ms. Nahara says, Your Honor, if I may, just to add so the court knows it was only a section of the tape that we played, and if we offered it, we would redact it depending on if the court rules it was admissible. We would redact it to just the admissible portion. The court says, my notes are that the small portion was played and I wrote down for the purpose, of impeachment. But I will certainly look at the transcript. Ms. Nahara says, okay. The court says, let me make a note here. Okay, then the next one. These are kind of boring, but we got to get through them. Mr. Gessler says, the next would be the series of 90, 91, 92, and 93. Again, interviews of Erik Menendez and Lyle Menendez. I believe those were the interviews conducted in the early morning hours of August the 21st of 1989, and our objections there are on the grounds previously stated, Aranda limiting instructions not being sufficient, all other grounds stated previously in writing and orally. Court says, okay, to whatever objections were made previously, the court's rulings in response to that, those rulings stand and the objections remained overruled and those exhibits will be received. That's 90 through 93. Mr. Gessler says the objection to Exhibit 100, Your Honor, I forget if I included that earlier. Ms. Nahara says, no, you didn't earlier. Mr. Gessler says, but that's again the general objection to the suspending evidence. It includes the board, I believe that has I'm sorry, it's not 167, it's the series where the Porsche is pictured, the patio home is pictured, and the condominium in Princeton is pictured, and the objection there is as to one's previously stated as suspending evidence in general. Court says, all right, those objections would be, guess what? Overruled. And that again, just to identify the exhibits, that's 100 through 104. So every single objection so far has been overruled by the court from the defense, just if you're keeping score. It always seems like the system is meant to have the defendant fail. It just I've lost so much faith in our system after covering these trials and watching court trials and hearings and seeing what's been happening. And it's not just what's happening now in current court cases, it's been going on forever and a day, and it's probably going to continue to go on forever and a day. So it's just very depressing, but it is what it is. All right, let's get back to it. So Mr. Gessler says 101 through 104, I believe, primarily, Your Honor. I think 100 is the life insurance policy, and that's okay. Ms. Nahara says, are you objecting? I'm sorry, Your Honor. Are you objecting, counsel, to 100 or not? 100 is the document of the life insurance policy. Ms. Tari says, no. So it is 101 to 104, Ms. Nahara asks. Mr. Gessler says, right. Ms. Nahara says, thank you. Mr. Levin says, and Your Honor, although counsel for Erik Menendez joins in with Mr. Gessler's stated objections with respect to the display boards that demonstrate or illustrate items purchased by Lyle or Erik Menendez, we believe they should be separated so that there are no display boards where the spending of Lyle Menendez appears with objects or items that are alleged to have been purchased or attempted to have been purchased by Erik Menendez, as it confuses the jury and may give an inference that otherwise should not stem from that particular exhibit. The court says, are you talking about a particular board that has photographs relating to spending by each defendant? Which board is that? Mr. Levin says, I believe I will check it again, but I believe it was in that 100 series where there were display boards presented, and it seemed to be more for ease of the witness at the time. I will check it, but I just want to make sure that that didn't occur. Court says, okay, I think they were all separated. The car and things were separated. I don't think there was any. Ms. Nahara says there was never what he was talking about. Mr. Levin says, I may have been confused because so many of them got up on the board. I think that was the problem. Ms. Towery says, you didn't use a board. That's right. Mr. Levin says, sorry. The court says, okay, then the next objection. Mr. Gessler says, would be to 110, Your Honor, which is a blow up of 109, and I think the jury can easily see 109, which is the check cashed by Mr. Whitkin for the Xerox services. 110 was used to, I think, for the jury's convenience in being able to see it, but it's cumulative. Court says, all right, although it is a duplication, it is an enlargement, and, well, let me see what the people's position is. We have a whole series of these, and we are going to have duplication basically of many exhibits that are enlargements of other exhibits that have already been referred to. Is there really a need to have both those to go to the jury, the original and the blow-up? Ms. Nahara says, if I may, Your Honor, I believe that this only takes place with regards to these receipts and also with the ATF records, and I don't believe that there is any. In fact, I know from what they have given me that there is no objection by counsel for the defense as to the ATF blow-ups. In this case, we would request that the blow-ups be allowed in. I think that they make it very clear to the jury. I believe that the witness also used them and marked them, and I believe that they were an integral part of his testimony, and also with regards to the ATF records, that as well. And I know with the ATF records, they also used them as part of the exhibits and all the information. So we would ask that all of them be admitted. I don't believe there is any objection to anything other than this. So in terms of the court's concerns as to other blowups, I don't believe there is any objections in terms of the other blowups. The court says, certainly we will have that with all the McCarthy documents. We have duplications of those, although there is a distinction there that the smaller versions were marked up in different ways by witnesses during testimony, so there is a reason to distinguish those. You're saying we don't have any others like this. Ms. Nahara says, that's my understanding, Your Honor, and with regards to the McCarthy ones, I believe the defense offered the small ones and we are offering the large ones. Court says, like I said, that's been different because there have been markings on those exhibits. Ms. Nahara says, as to these blow-ups, Your Honor, I believe it is just these and the ATF records. Mr. Gessler says, I am not objecting to 111 because there is no small version of that evidence in the blow-up only. Or it's the blow-up only. But for 110, I am objecting because it's duplicative of 109, and I don't think that 110 was marked on by the witness, even though 111 may have been. Court says, okay, 110 is the blow-up of the check. Is that correct? That's correct, Your Honor. Court says, okay, I'm going to sustain the objection to that. There is no need to have both, and you're saying he marked one and not the other. Is that what you're saying? Mr. Gessler says, I believe, Your Honor, what he marked as 111, which is the service authorization and receipt, and that's fine because there is no original in there for 111. The court says, okay, 109 would be received then. 110, Ms. Nahara says, Your Honor, I'm sorry, I didn't mean to interrupt you, but I just wanted to say that if it's the court's feeling that it's cumulative, we would offer 110, the blow up, and withdraw 109. The court says, I think the original document should go in and you can use 110 for argument purposes. Ms. Nahara says, okay. The court says there is nothing about that. There's nothing about it that justifies it going to the jury other than just some document that could be used for argument purposes. 110 will not go in. What else? Mr. Gessler, so there's one win for the defense, but kind of not really. I mean, it's a mini win. It's a barely win. So Mr. Gessler says, I am objecting to 116, Your Honor, on two grounds. The general spending grounds, this is the blow-up of the Rolex watch. And the second objection is that it is not the same type of watch as was purchased by Lyle Menendez. This one has the emeralds on the dial. That makes it substantially different from the version or model that was actually purchased. The court says, well, it appears to be substantially the same, but for the dial, and that had been explained through the testimony of this witness. So, as a general illustration of the type of watch purchased, it is substantially similar. The witness did explain in her testimony the difference in the purchase price between a watch with the type of dial and the watch actually purchased by the defendant. The watch that Lyle purchased was cheaper because it didn't have the emeralds, obviously, but she used a picture of a sample watch of that same line, but like of a higher version. So it's kind of misleading the jury, if you think about it. Even though she did give the testimony, it's still like, why couldn't you work for the company? You could have given us a better picture, a more accurate picture, but whatever. Continuing on with argument, he says, so I don't think there's anything misleading about it in any way or inflammatory. Therefore, the objection is overruled. So he's going to let it in, which I think is stupid. Mr. Gessler says, I would also object to 117 and 18. This is the other two Rolex watches that they are not identical to the ones purchased, and also on the general spending evidence grounds that we objected to before. Court says, right, those objections will be overruled. The court finds they are substantially similar, and weighing them under Section 352 of the Evidence Code, the probative value substantially outweighs any potential for prejudice. And what else do we have here? Mr. Gessler says 119 is the same objection. That's the receipt for the Rolex. That's on the spending grounds, relevancy, and 352, Your Honor. Court says, okay, that'll be overruled. It's like, really? Mr. Gessler, I mean, yeah, I'm not surprised. This happens all the time everywhere, but it's just blatant to see when you read it and pay attention. You don't know, like when you're following a case, you don't necessarily follow the trial and all the evidence that is or isn't allowed to come in. And once you see like how much control a court has over the evidence, it's insane. And if you have a biased judge in any way or a biased prosecutor and a judge that's going to lean towards prosecution, it's sickening that this happens everywhere. So the court says, okay, that'll be overruled. Mr. Gessler says, I object to 120. This is a past recollection recorded of witness Mary Maher and should not come in based on the fact that it was a people's witness and only if offered by us, which we are not. And the court says, okay, that is my notation as well, so it will not be received. Mr. Gessler says, let's see, 122, the tennis contract with Erik, and 123 and 24, the pictures of the Marina City Club. Again, we renew our objection on the general spending grounds that we objected to before, relevancy in 352. Court says, okay, those objections previously hanging been overruled. The court again overrules them at this time. Mr. Gessler says, I would object to 125, a tape of a transcript, actually of a tape of Mark Heffernan. My recollection is that he was used only to verify the time that that particular conversation ended. I don't remember that tape being. The court says, which exhibit are you talking about? Mr. Gessler says, I am talking about, I believe it's 125, Your Honor. Court says, that's a transcript. Mr. Gessler says, a transcript of a tape, Your Honor. The court says, okay, transcript of an interview of Heffernan by Edmonds. Mr. Gessler says, yes, I guess you're right. It was a transcribed interview rather than a. The court says, right. I don't know if it was a tape. It must have been because I wrote down transcript of interview. Ms. Nahara says, yes. The court says, and your objection is that it was? Mr. Gessler says that it's hearsay, Your Honor, that it was offered, I believe, on cross-examination only to develop that time that the interview ended, not for the substance of what was said, and that the transcript itself, I don't believe, was gone into as I recall. The court says, was a portion of it read to the witness? Mr. Gessler says, I believe it was just shown to him for time. I can't recall right offhand if it was read to him, so if so, it was only the last line, I believe. The court says, I have nothing here to indicate how it was presented to the witness, so what is the people's motion or position on this? Ms. Nahara says, Your Honor, that's something I was under the impression, I could be wrong, that it was read, but so much was read, I'd like to check it. The court says, if it was read, then the reading of it is in the record in the transcript itself, and it need not go to the jury. There is no reason for it to go to the jury. Ms. Nahara says, may we check that, Your Honor? The court says, yeah, we will hold off on that one. Ms. Nahara says, thank you, I'll find it. Mr. Gessler says, we renew our objection to 127 on grounds previously stated. That's the Mossberg exemplar shotgun, Your Honor, and again on the grounds that it is not operative in one of its major relevant capacities. That is for the taking out of the dowel. I remember Mr. McCarthy struggled with it considerably on the stand, also in trying to get that to perform, just as did the salesperson. And so for those reasons, it is not an exemplar truly of the shotguns that were purchased, and on all other grounds, too, we would object. The court says, well, it seems to me that the defense earlier had stated that you were not pursuing an objection on the grounds that this weapon was not substantially similar to the weapon purchased, and you weren't disputing that. Your problem was with the mechanism not working, that particular mechanism involved. Mr. Gessler says, that's what I meant. We're not saying it's not the same model or close enough that they have to bring somebody in from the Mossberg company. What I'm saying is this weapon is inoperable in a sense in which the weapon purchased was operable. So my objection is that aspect of it. The court says, all right, as I indicated before, if the particular mechanism becomes material to the case and the mechanism is supposed to be operable and is not, then it must be repaired by the proponent of the evidence because before it is received in evidence, and the proponent is the prosecution. Now, as I understood McCarthy's testimony, he didn't think that this was supposed to be operable anyway. Maybe I'm misunderstanding him, but that's the thrust of what he was saying, although I got the impression also that he felt he could have removed it with the proper equipment or the proper time, and it might be the type of device that requires certain tools to open it up. Mr. Gessler says, not according to the salesperson, who seemed to have great familiarity with this weapon and great ease with most of them. Court says, yeah, like I said, if that particular issue becomes relevant, then that weapon would have to be repaired before it becomes admissible. If there is a dispute about whether that particular mechanism is substantially similar to the type sold to the defendants, then the people would have to repair it. Mr. Levin says, well, Your Honor, there may be a question with respect to the similarity of the shotgun if Roger McCarthy's testimony is that that particular shotgun does not have this function, or does have that function. The court says, I am not sure if that's what he said. It's a little ambiguous as to what he meant. He was fiddling with that particular mechanism, and as I recall, he testified that the norm is not that weapon is not sold with the plug in it. Mr. Levin says, that's what I thought he said. Ms. Nahara says, that is what he said. The court says, but that's contrary to what the store employee testified. Mr. Levin says, that's what I understood. The court says, but there's a question, first of all, as to McCarthy's knowledge of it and the basis of his knowledge, and secondly, as I said, if it becomes an issue either during the people's case or the defense case, then that will have to be repaired to show that it is substantially similar to what was available in the store. So we'll hold off on that, the offer as to 127, because it still has to be resolved insofar as that particular portion of the weapon. So we are not going to rule on that yet. That will be under submission pending further evidence. Mr. Gessler says next would be 130. Again, on spending grounds, that's a picture of I believe, the Marina City Club. Ms. Nahara says, right. The court says 130 are purchase documents for the Marina City Club. Mr. Gessler says purchase documents, that's right, same grounds as the spending evidence on the other Marina City Club. Court says, okay, the objection is overruled. Surprise, surprise. Mr. Gessler says next would be an objection to 135 and the uncompleted sale by Erik Menendez or purchase on the Silver Strand home on, again, the spending grounds previously argued. Court says, okay, that's the photograph of the home. Mr. Gessler says, yes, it is. Court says, okay, that objection is overruled for the same reasons previously stated by the court. Mr. Gessler says 136 we would object to as the Jeep. I don't believe there's been any showing that the pictured Jeep is the same that was purchased or that type that Erik Menendez purchased. And I think an objection was earlier sustained to showing that picture. Court says, well, there was an earlier objection. There was an offer by Ms. Abramson to have the actual vehicle photographed in her possession. But the witness testified that the vehicle photographed was a standard model, as I recall, and that the defendant had purchased something which had more equipment on it than the one that was photographed. So, if anything, the vehicle photographed in 137 has less of the equipment than the one actually purchased by the defendant. Mr. Gessler says that is the Burge package or something like that. The court says, so it's substantially similar to the one purchased, but doesn't show off all the additional equipment, whatever it was they attached afterwards. So my view is it is substantially similar to the one purchased by the defendant, and the objection is overruled. Mr. Gessler says, along with that, we object to general spending grounds, both to the picture of the Jeep in 137, the documents, and check for the purchase of the Jeep. Court says, okay, and that is overruled, and I assume that when you're objecting, the objection is on behalf of the co-defendant, Erik Menendez. Yes, Your Honor, says Mr. Levin. Court says, okay, and the next exhibit, Mr. Gessler says it would be, let's see, you're offering both 141 and 42. 141 is the unredacted escape plans, I believe. Ms. Nahara says, right, it should be 142. 141 was just the escape plans, which the court already ruled had to be redacted, and they were redacted in conformity with 142. Court says, so 141 is not received. 142. Next, Mr. Gessler says, we are objecting to 142 on all previous grounds and lack of foundation. The court says, okay, that document will be received based upon the previous rulings of the court. And then the next one, Mr. Gessler says, I just wanted to make a note, Your Honor. I'm sorry. Court says, sure. Mr. Gessler says, 143, the redacted as laminia letter, we object on all previously stated grounds. The court says, all right, the objection is overruled and it will be received. Okay. Mr. Gessler says, and we are objecting to 147 and 148, the condo sale and the house sale in Princeton. We stipulated to foundation, but we renew our objections based on the general spending evidence and relevancy. Court says, all right, that will be overruled on previously stated grounds. Mr. Gessler says, we are similarly objecting to 149, the documents for the purchase of the restaurant, Your Honor, on the spending evidence and relevancy under 352. Court says, all right, the court's ruling is consistent with its ruling that this evidence would be admissible. The particular documents are also admissible, and the objections are overruled. One sustained, I think, so far. Maybe two, if I recall. I'm not sure, but mostly overruled. Mr. Gessler says, we also object to 150, Your Honor. This is the documents on the Porsche sale based on the general spending grounds and also lack of foundation. The only evidence I believe offered so far has been Glenn Stevens, who accompanied Lyle Menendez to the Porsche dealer and believes it was at the time with a check. But he really was in no position to authenticate those particular documents. The court says, My notes indicate that on October 31st, Mr. Stevens identified the check. Mr. Gessler says he did. Court says, and then that's the only document that he could identify, and therefore that would be the only document that he received because it's the only document at this point that's been identified. So only the check, which is a part of 150, will be received. Mr. Gessler says, and our next objection, Your Honor, would go to 166, which I believe is a police report concerning statements by Mark Heffernan. Again, I believe that was offered for refreshed recollection or past recollection recorded, and it should not be offered by the proponent. The court says, what's the people's position on that? Ms. Nahara says, Your Honor, that once again is a document which we believe needs to be redacted and in its current form would not be admissible, but redacted to past recollection recorded of an official statement would be admissible. The court says the law is the past recollection recorded is the testimony regarding that, not the document itself. The document doesn't come in. Ooh, that's a win for the defense. What's that, 2 now? Ms. Nahara says that's correct, Your Honor. The court says so it will not be received. Ms. Nahara says, yeah, that's right. Mr. Gessler says those are the objections that I had noted up to the time of the medical testimony, Your Honor, and I don't know if Mr. Levin has additional. Mr. Levin says, no, Your Honor, just that we join with Mr. Gessler's objections. The court says, all right, just so the clerk now can do the paperwork for those items that are being offered and not objected to, let's have the people just identify which exhibits you are offering and have not objected to. Just go 1 through 25 or whatever it is. Ms. Nahara says, Your Honor, I've got the list of what we offered and we'll give you the whole list and we will already have the list of what's coming in and out if we can do it that way. 1 through 28, 30 through 60, 67, 70 through 75, 79, 80 through 86, 89 through 93, 97 through 104, 108 through 111, blah, 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 blah. I can read it all. Ms. Towery says, is that 141 or 142? Ms. Nahara says 142, thank you. 142 to 143, 147 to 140 or 150, and so on and so on. The court says, all right, let's then go through them and I will just rule on those that are being received. Okay, 1 through 28 are received, 30 through 35 are received, 37 through 459 are received. We are holding off on 60, which is the transcript of the tapes so that we can have further resolution of any disputes. 67 is received, 70 through 75 are received, 79 is received, 80 through 86 are received, 89 we're holding off on, 90 through 93 are received. How do they keep track of all this? Blah, 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 blah. Ms. Nahara says, excuse me, Your Honor, 122 to 124, I think we had. The court says, I'm sorry, 122 to 124. Court says, 122, 23, and 24 go in. Ms. Nahara says, and 125 we are holding off on. The court says, that was again an interview of Heffernan by Edmonds. Ms. Nahara says, right, we were going to check and see. The court says, you were going to check on this point. Ms. Towery says, I can give you that transcript citation right now. It's volume 229 at page 38, 134, and it does appear that it was only used to refresh his recollection regarding the times, as best as I can determine. Mr. Gessler is correct. Ms. Nahara says, okay. The court says, and Ms. Nahara says, I will check that. The court says 135, 136, 137 received, 142 and 43 are received, the same 147 through 150 are received, 166. Ms. Towery says, Your Honor, I think 150 only the check portion was received. The court says, yeah, the check, that's right, as I ruled before, 166 is not received, and that is what the defense was objecting to. The ones now that you're holding off because of current testimony. Mr. Gessler says, yes, Your Honor. Court says, which ones starting at 167? Mr. Gessler says, that's correct, Your Honor. The court says the x-rays and things. Mr. Gessler says most of those will be no problems. The x-rays, that's the simplest part. I don't think we will have a lot of problems resolving those issues, but we prefer to wait. Court says, all right, we will hold off on those. All right, then let's get to the exhibits offered by the defense here that the people are objecting to. Let's hear the people's objections to defense exhibits so far. Ms. Nahara says, thank you, Your Honor. The people are objecting to Defense Exhibit 65. That was a group of over 10 defense photos from 165 to 75 to 65 to 75. We are objecting only to 65, which is a photograph of the bedroom, which apparently has some dog feces in it, and we would object to that. We don't believe that it really has any relevance to the case. It wasn't a photo of the crime scene. It wasn't a photo of the of any evidence. It was simply a bedroom in the house with feces in it. The court says this is the only photograph that you are objecting to of the house. Ms. Nair says, correct, Your Honor. There is a group of them from 61 to 75, and we are not. That is the only one we are objecting to. Just an FYI, it's been testified to by multiple people in trial one that Kitty and Jose were not very cleanly. They had maids, but they didn't they didn't clean up after themselves. And they had boxes that were unpacked from all their moves and things that they never got to, just lying around the house, and they were not very clean. And so the fact that, there was dog feces lying around, there was ferrets that they had, animals running around, um, you know, excrementing all over the place. It wasn't the cleanest of homes. So I don't know what the point of the photo was, but that is just an explanation as to why that photo might have been available to take. So the court says, all right, on the basis that these are generally photographs of the house and the entire house is the crime scene, the objection is overruled, so it will be received. What other objections? Ms. Nahara says, also, Your Honor, the people are objecting to Defense Exhibit 76. This is the 22 rifles, and we don't believe that we have any relevance, or that they have any relevancy. I believe these are Kitty's guns. The court says, okay, at this point they don't, although they were mentioned in the September 17th interview of one or the other defendant. I don't recall which one in New Jersey. There was some mention of that. The relevance would have to come during the defense phase of the case, so at this point I won't receive that, but I am going to rule it's admissible. It will have to wait for the defense. Ms. Nahara says, okay, and the next thing that we would be objecting to, Your Honor, is Exhibit 140 as it currently stands. It is an exhibit of which was used along with 183 and 138, and 139, I've got dyslexia, by Wesley Gross to do a handwriting exemplar, and I believe its only relevance was with regards to Mr. Gross's testimony that he used this writing as something he examined to determine whether or not this handwriting to make an opinion concerning the handwriting on the ATF records. Court says, okay, let me hear the defense position on that. Ms. Tari says, well, Your Honor, I think that his testimony was that he could not eliminate Lyle Menendez as a writer, and the crux of the cross-examination of Mr. Gross was the techniques that he used and how he went about making his determination, and he used the 3 documents that were marked as exhibits in making his determination. 2 of them related to the handwriting of Donovan Goodrow, and 1 related to the handwriting the known exemplar of the handwriting of Lyle Menendez. So I think the jury should be entitled to review those documents and make their determination, because they are the triers of fact as to whether or not Lyle Menendez was the writer of those documents. Court says, well, as I understand it, the defense represented to the court prior to commencement of trial in response to the people's proffer of evidence relating to the defendant's refusal to provide handwriting exemplars that the defense would not be contesting the fact that the handwriting in question was that of Erik Menendez. Ms. Towery says, well, the defense isn't contesting that it's that of Erik Menendez, but I represent Lyle Menendez, Your Honor, and my cross-examination was relating to the inability of Mr. Gross to exclude Lyle Menendez as writer of the document. Erik Menendez may well take responsibility for having written the name Donovan Goodrow on those documents, but certainly during the people's case, we can't count on that. And defense for Lyle Menendez is entitled to cross-examine to try to exclude Lyle Menendez as the writer of that document. The court says, well, as I said, one of the reasons the court was holding off ruling on the people's proffer of evidence was to determine what the position of the defendants was in regards to contesting the author of the signature. Ms. Towery says, that's not the only handwriting evidence that's been offered by the people. We, on behalf of Lyle Menendez, we stipulated that he wrote the Brian Eslaminia letter, so we did not contest that or require that any evidence be presented. However, he didn't write the Donovan Goudreau signature. Court says, well, the people aren't contending that he did. Ms. Towery says, well, the people aren't contending that anyone did, that Mr. Gross couldn't say who did, but he couldn't eliminate Lyle Menendez. That was the whole point. The court says, okay, well, at this point, I will hold off a final ruling of this. The people's position has merit that the content of the writing was material that makes its receipt potentially more prejudicial than probative. However, I will await the defense presentation of evidence to determine what the posture of the defense is as to the author of this particular signature, and as I indicated earlier, to some extent the court's ruling on the people's proffer of the refusal to provide a handwriting sample is derived from the defense position on that issue. Ms. Towery says, well, can I just add one other observation, Your Honor, and that is that Mr. Gross did testify that additional exemplars would not have assisted him in making his determination, and he had sufficient exemplars to make a comparison and reach a decision as an expert. Court says, all right, but I'm not aware that that was the situation, and I don't recall now what the issue was as to whether or not he knew that or the people knew that at the time. And that, more importantly, whether defendants knew that at the time the handwriting exemplar was sought. Ms. Towery says, I can represent to the court that it was in his initial report. Court says, okay, but the defense, I don't believe, has had access to it or didn't know at the time. That's my recollection of how that occurred at the time. It occurred in municipal court. But overall, I will hold off ruling on that pending further presentation of evidence by the defense. What's the next one? Ms. Nahara says, Your Honor, the people are objecting to Defense Exhibit 151. This was a letter from the witness Jamie Pisarcik to Lyle Menendez. It was used only to refresh her memory, and I believe it had hearsay in it. Court says, okay, that's my notation as well. It was used only to refresh recollection. Did you wish to be heard on that one? Ms. Towery says, Your Honor, I indicated to Mr. Gessler, Ms. Nahara gave us the list just before the court came out as to the documents that the people would be objecting to and the letters that I used with respect to Jamie Pisarcik. I just can't remember what purpose I used each letter for. I only have a terse description. So what I ask is to be given a chance to look through and see what documents were only used to refresh recollection and which ones were used as actual evidence. As I recall, the people objected to a number of the documents on the grounds that they spoke for themselves, and I wasn't permitted to inquire into the content other than to just authenticate the documents through Ms. Pisarcik, in which case, obviously, it would be unfair to permit them to make that objection and not let the jury see the document that supposedly speaks for itself. So I would want to go through. There are a number of them, and I feel that since her testimony was fairly lengthy, it's hard to go through and find them all right now and make that determination. So if the court would give me until tomorrow of that, I would appreciate that. The court says, okay, sure, but we'll hold off on it until we have some time to litigate it without inconveniencing the jury. Ms. Towery says, okay, that's fine. Whatever the court wants. I just don't want to be unprepared to respond for the purpose for which each document was used. Court says, that's fine. That's fine. We can hold off on all those that relate to Pisarcik then that are in that category. Ms. Towery says, I think that was 151 through 163 that the people were objecting to. Is that right? Ms. Nahara says, that's correct, Your Honor. We would be objecting to a whole series of writings dealing with Ms. Pisarcik. Court says, okay, and that's it? Ms. Nahara says, and that's it. Court says, okay, let's go through the exhibits that the defense is offering here that either are not objected to or are being received here. There aren't that many exhibits at this point. 61, you're not offering that at this point. 61, why don't you tell me what you are offering. Ms. Towery says, yes, I'm sorry, Your Honor. Yes, we are offering 61 through 66. Court says, okay, 61. My notes indicate that there was no identification by Detective Zoller of the document October 16th. Now, whether it was picked up later on by other witnesses, I don't know. Ms. Towery says that was the receipt for the court says purchase of the rifles. Ms. Towery says, of the rifle. I have a vague recollection that Mr. Beralt authenticated that through a serial number, but I am not sure. The court says, it's possible that he did. I won't dispute that. Ms. Towery says, in any event, I don't think the people are objecting to it. We gave them these numbers and they didn't object except for the ones Ms. Nahara indicated. So let me just give the court a list of the ones that we are offering because I have the list in the same fashion that she does. Ms. Nahara says, right. Ms. Towery says 61 through 66. Court says, okay. Are there any objections to those? Ms. Towery says 65, I think it was. Ms. Nahara says, no, Your Honor, just to 61. The court says 61 through 66 will be received then, and 66, 66A and B as well. Ms. Towery says, all right. Ms. Nahara says, all right. Ms. Towery says, and then 68 and 69. Court says no objections to those. They will be received. Ms. Towery says 76 through 78. The court says they will be received. Ms. Towery says, actually, I think the court held off on 67. Ms. Nahara says, Your Honor, 67. Ms. Towery says, a ruling on 76. Gosh, I am dyslexic in my old age and brain fog from my diseases and stuff. 76. I kept saying 67. You guys, bear with me. I'm sorry. 76. Ms. Nahara says, yes. And the court says, okay, let me back up here. Ms. Towery says, so 77 through 78. Court says, hold on a sec. Yeah, I forgot that. Ms. Towery says, all right. The court says, and the defense is offering 78. Ms. Towery says, yes, 77 and 78, to which there are no objections. Court says, okay, they will be received. Ms. Towery says, 87, 88, to which there are no objections. Correct. They will be received. 105 and 107. Okay, they'll be received and blah, blah, blah until the end of time. They're just going through. Okay, so let's get to the end of that. Ms. Towery says 138 through 140. Ms. Nahara says, oh, I'm sorry, we didn't object to 138 and 139. If I said that, I misspoke, that it's 140. Ms. Towery says, so 138 and 39, there is no objection. In 140, the court has indicated it would hold off on rule. Ms. Nahara says, that's the one in abeyance. The court says, right, waiting for the defense. Mr. Gessler says, correct. Ms. Towery says, so the court is receiving 138 and 39, correct. Ms. Towery says, and then 151 through 165, the court indicated that we could litigate 151 through 163, 64, and 65. There is no objection. Court says, okay, 164 and 165 will be received. The others will wait for you to check the exhibits. Ms. Towery says, and that's it. Court says, let's go through them. There seem to be some here that aren't being offered by either side. Let's verify that. Again, Your Honor, we stopped starting with Exhibit 167. The court says, right. Nobody is offering 94, 95, or 96. Mr. Gessler says that's correct. Ms. Nahara says that's correct. The court says, so they won't be received. Nobody is offering 121. Mr. Gessler says that's true. That's the Eslaminia letter before it was redacted. Court says, right. Court says, okay, so that's not received. 144 and 45. Ms. Towery says, I think 141 wasn't offered either. That's the escape, so-called escape plan before redaction. The court says, yes, we talked about that one. 144 and 145 and 146. We're almost there, guys. I know this is a long and boring one, but this is important stuff that happens at trial. They got to sort this stuff out, too, so it's got to be on the record. Mr. Gessler says not being offered. The court says, and they will not be received. And then we have the Psarstic material. Ms. Nahara says, right. The court says, and then that takes us to 167 and the bulk of the material that is currently being used by counsel in the examination of Dr. McCarthy. Ms. Nahara says yes. The court says, okay, so I will look at Exhibit 89 and the transcript, and there was one or two things that counsel were going to look at in addition to the Pitharsic material, and when we have another opportunity to discuss exhibits, we will do that. Ms. Nahara says 36 and 60 for us. Court says, okay, anything else at this point? Mr. Levin says no. Mr. Gessler says, that's it. Court says, okay, well then we will be at recess. And that is the end of their arguments. And we will pick up in the next episode, starting with Dr. McCarthy's testimony. Again, the mechanical engineer, not biomechanical engineer, and we will pick up with his testimony right where he left off. Remember, he ended on Friday, couldn't be here today, which is Monday, so he'll pick up Tuesday, November 14th, 1995, if you're keeping track of the dates. So that is where I leave you. So thank you guys so much for watching. Please hit that like, subscribe, leave a comment. Let me know what you think. What's going on in your mind regarding the Menendez case? So far, I'm not impressed with the state's theory, the state's, supposed new witnesses that, they're not really experty, in my opinion. They're not as experty as the expert witnesses that are going to be coming for the defense, I'm sure. So we'll see. At least that was the case in trial one. The experts for the defense were excellent, and there was no expert. Their expert was Dr. Oziel, basically. So it was pretty pathetic. So at least they brought I don't know, because Oziel's not even testifying. So, but they're using the tapes against them, of course. So it's a different trial, different rules, same judge, different rules, I guess, is how he's playing it. So let me know what you think about the different rules this time around. And I will see you guys in the next one. Take care, and I'll see you guys tomorrow. Bye.